Sent that this morning, actually, along, I did a notice of filing, so that will make it through the portal at some point this morning, if it hasn't already, but I did send that, email that to, Division 52 in this bus, so just so everyone got it right away.
All right, was there a particular reason for sending me that case?
Your Honor, I believe with the intent argument yesterday that we had, as far as I believe the subsection A of Ms. Leslie's written motion, that there was not direct evidence of Mr. Lane's intent, and that the evidence that was presented, or I guess the direct evidence of the statement that he did it for, I guess, apparently innocent purposes to figure out why Ms. Lane was cheating on him to get closure. I sent the Bush case. I know it's not directly on point, but it does talk about the fact essentially abrogates the prior, my reading of it abrogates the prior case law with respect to circumstantial evidence, and it says that the state does not have to absolutely disprove every innocent explanation. I think I also made arguments yesterday that I believe that that explanation could also fall under the elements of intent as far as amusement and entertainment, but as I was thinking about it this morning, I thought about that Bush case. It was a more recent ruling and thought it may be relevant, so I wanted to send it out to the parties.
All right, anything to add to that, Ms. Leslie?
I just got it this morning, so I'm still processing it. I've had, I know that actually Bush is old, and originally I was one of the interns that had it years and years ago, but then I transferred to Putnam. But I'm aware of the facts in Bush, obviously because that was a death case and it was a murder. It was a very different type of intent, different type of crime, obviously very distinguishable facts. I am aware of kind of how the case law has evolved in the area of circumstantial evidence, specifically in the Seventh Circuit coming out of St. John's. I believe there's a case a couple of years ago, 2017, I believe, that really cut away at circumstantial evidence being used by the state.
Well, I think the Supreme Court in Bush took a meat cleaver to it and basically said there's no special rules now for circumstantial evidence. It's evidence.
Right. I still, while I agree that obviously that type of evidence exists, I still contend and would argue that it doesn't negate the lack of proof on a specific intent crime.
Okay. All right, thank you. All right, I have considered all of the arguments that y'all made yesterday, and going specifically to your point one about the absence of evidence of an intent, I do believe that there is sufficient evidence with viewing the evidence in a light most favorable to the state on both counts 1 and 2, that there is the specific type of intent as stated both in the statute and actually laid out in the information in the actual charge. I'm going to use a shorthand term here for the long list of reasons, but the statute, and as they're cited in the information, talks about is amusement, entertainment, sexual arousal, gratification, or profit, or for the purpose of degrading or abusing Melanie Ames, and then AA as well. And I think that the state has put forth evidence of several of those bases. And it's not appropriate at this time to weigh the strength of the evidence. At this point, I think the state is entitled to move forward on the case in that regard. So I'm going to deny on that basis. Going to the issue with count 4 about the two-way communication device. You start by analyzing any statute by reading the plain language of the statute. And what is important about this is not just the existence of a two-way communication device, but the specific purpose that's stated in the statute, which is to facilitate or to further the commission of any felony offense. And in that regard, the definition of facilitate is to render easier the performance of an action or to provide facilities for an action. And if you look actually at the White's case, which I think you gave me for a different reason, but in the White's case, it specifically states that 934.215 does not require proof that content was actually sent by a device. And the footnotes of White's are even more illuminating. Footnote 2 notes that trading trading a gun for drugs under there's a U.S. Supreme Court case cited in there. In footnote 2, Smith versus United States at 508 U.S. 223, pages 228 and 29. And the specific notation says, holding that exchanging a firearm for narcotics constitutes use of a firearm in relation to a drug trafficking crime because the firearm was actively employed, albeit not as a weapon, but was integral to the transaction. And I think that integral to the transaction language is actually what's very important here. In this particular case, I believe the state has presented evidence that the use of the cell phone was integral to the other crimes, which is the definition that 934.215 seems to call for. So I'm going to deny the motion on that ground as well. And I think that also addresses your ground C, which was a quasi double jeopardy as well. The issue on ground C that I would also point out is that while the cell phone was used for part of the actions in counts 1, 2, and 3, the element again, as stated in White's, is not the same as is required in those statutes. And in addition, in counts 1 and 2, specifically would note that the camera device was a dual purpose. It could both record images and it could transmit them. So there's a whole separate element there. The state could meet their burden simply by showing that he recorded, having nothing to do with transmission. So I think it is a separate element. And so I'm denied on that basis as well. All right, you ready to proceed then, Ms. Leslie?
Just in light of the court's ruling, I would ask for a brief moment to speak and discuss with my client to strategize as to how we proceed going forward.
Okay.
I know because of how the layout is and to try and maintain distance, is it possible to have the judge and state maybe be excused or us to go somewhere else so that we can talk privately?
I don't mind stepping down.
Yeah, we can all step out. That's fine if they also stay in here.
Thank you.
Yeah, we'll just be in recess, and I'll also stop the. I'm going to go ahead and mute the Zoom feed now,
Okay.
and also stop the recording system here. All right, you ready to proceed?
Yes, Judge.
All right, thank you. Ms. Leslie?
It is the intention of the defense to rest at this point. I believe it would be proper to inquire as to his desires to testify or not testify. And then to, I guess, further instruct or go on the record and explain, obviously, with the impending case, the secondary case against the violation of probation case, obviously any testimony here today would be used against him. So just so that he's fully informed of that fact.
All right. All right, let's place Mr. Lane on the road for today.
You solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, thank you, Mr. Lane. You can be seated, sir. Counsel has indicated that you don't wish to testify in this case, and the defense is going to rest at this point. First off, if you had enough time to talk over all these issues with your attorney?
Yes, sir.
And you're satisfied with her representation at this point?
Yes, sir.
All right. You understand that under the Fifth Amendment of the United States Constitution, you have the right to remain silent, therefore have the absolute right not to testify. If there was a jury here, I would instruct them, and I will note that I'm taking under consideration for myself that the fact that you have not testified is not to be used against you in any way whatsoever. That's an absolute right that is granted under our Constitution to every citizen, and will not be used against you. Secondly, as a defendant, you also have no obligation to put on any kind of defense whatsoever. The state has the burden, and it remains with them throughout the entire trial to prove that you are in fact guilty beyond the exclusion of reasonable doubt. And there is no inference that is taken from the fact that the defendant has not placed anything in defense. There's absolutely no reason why you have to do that. So I want to make sure you had that discussion with your lawyer.
Yes, sir.
And you're comfortable with that decision.
Yes, sir.
And as Ms. Leslie pointed out, there is also a pending BOP case. But as I noted yesterday, I believe it is largely dependent on this particular case, and it's not really being taken into consideration today whatsoever. And that may be one of the reasons why you have chosen not to exercise your right to testify if you wanted to. You have two competing rights: to remain silent and to testify. And you're comfortable with that decision.
Yes, sir.
All right. All right. Anything else that either party wishes for inquiry?
Judge, I would renew my judgment of acquittal. I will rely on the previous arguments made. I did have some additional arguments to make. It's not as extensive as yesterday, I promise. I find, and I told it, you're finding an interpretation of the White's case, in particular reference to footnote 2, integral to the transaction. I do find that an interesting take on the analysis. I tried to kind of harken back to your hypothetical or example of the plane. And I remember you said, if the plane takes off, it doesn't land, it's not a plane. And I was like, that is kind of strange.
Well, not an aircraft carrier.
Right.
Was the analogy.
But so the way I thought of it is we have so much technology. And so it's like if a phone was used to take a picture, because it has the capability of being a two-way communication device, then the state can charge that count in theory on almost every single crime if a phone was somehow involved. I think what has to be more emphasized is if it was used as a two-way communication device to facilitate. And in this instance, the phone, which is the item or the device that the state has claimed is count 4, has not been used in a manner that is a two-way communication device. I know it might sound stupid, but I'm just coming back to the plainest and most simplest understanding of it. I think the analogy with the firearm, it's different, I just think that's significantly different when we're talking about phones. I mean, phones are in everybody's pockets, they connect to things, the tracking, catching, those types of things. I think it's just really hard if we just say that because a device that is capable of being a two-way communication device was involved or somehow present in part of the other crimes, then that's the unlawful use of that device. And I just think that's kind of the wrong analogy or the wrong analysis. And then I keep thinking back to how video voyeurism cases are charged. Everything on a video voyeurism would have some type of technology. So if a person, is in a tanning salon, for instance, or a bathroom stall, slips a phone underneath, and there are cases I presented, I cited to them in the original motion, where they're slipping phones under stalls to take inappropriate photos, or over the top of the tanning salon to take inappropriate photos. But you don't see the unlawful use of a two-way communication device charged in those cases, because the taking of the photo is one action. It's using what is capable of being a two-way communication device, but it didn't facilitate the communication in furtherance of the crime. And I think that's why it's often paired with the traveling cases, because it is those cases hinge on communication. So I really do think that the communication aspect is the key kind of part to this. And I just don't see it here. There's so many apps that are linked to phones, and the way the phone acted in this case to me is like a server. It wasn't communicating anything. And then viewing something, listening, like a listening device, like was explained to us by Detective Gentry is what is used with law enforcement for drug cases, is it's one way. They can't communicate with the CI or whoever. They can only listen. It's one way. And that's, these devices that he had were very specifically one-way devices. They were imaging devices, recording devices, listening devices. Even by the namesake, they don't rise to the level of a two-way communication device. And I think to say that it's integral to the transaction, and again, it's a different take on that argument, and I'm still processing it, but to say that and to apply that in this case, I think the precedent that would set would be very far-reaching, and that's what I worry about. So again, I just do not think that the state has proven anything with regard to the fact that a two-way communication device was actually used in this case. Then going back to transferred intent for count 2 of the information, there is a case. So, as Your Honor knows, I like the history of things. I go back, I research very far back to understand things. The original cases on transferred intent come from the 30s. They come out of the Prohibition era, where things were getting violent and more seedier in the streets, and statutes for battery were not well written at the time. They would actually, it would be not to touch someone inappropriately or to cause injury, it was to maim. And then maim was a very loose definition and it wasn't defined. And so transferred intent was actually very narrowed at that time. Transferred intent actually wasn't being applied in cases in the 30s and into the 40s. Later you kind of see the kind of erosion of that. Transferred intent can be used for many things. And I think that's where it transitioned into the gun crimes, right? And there was almost kind of an additional analysis. It was transferred intent when the behavior was reckless, shooting into a crowd. Well, of course, like if you're maybe intending to get one person, but you're shooting into a crowd of people, there's a reasonable person would assume you intended to harm everyone. or someone.
Let's keep your analysis simple. If you're gonna use the firearm analogy, you fire a bullet at one person, fully intending to do great bodily harm to that person. And you have the misfortune to use a regular copper jacketed bullet, not a hollow point, and that bullet passes right through person A and buries itself in person B. Is the defendant then innocent of an aggravated assault on person B because he didn't intend to hit person B, but did? Isn't that the genesis of transferred intent?
Sure, I mean, that's the textbook law school examples that we get, I understand that, the bullet analogies, I'm thinking that's an added element of analysis, but, I get it, I see it. And in the cases where, so again, history of it is that transfer intent was really strict, it didn't apply to a lot of things early on, and then it expanded in the 80s and 90s. The more recent case that I was able to find was from 2010, I went back to the 30s. It's not exactly on point, I will agree with the state, will probably point that out. SG, Leach State, 29, 7/3, 383, February 26th of 2010 from the 5th District. It is a case about transferred intent, and transferred intent can't be used to enhance. So for instance, in this case, it was a juvenile in school, he threw a stapler at another student, intended to hit the student, missed the teacher. And they said that because the difference was obviously an enhancement, between a first degree misdemeanor and a third degree felony because of a state employee, that transferred intent doctrine could not be expanded to apply and allow the state to charge the juvenile with the third degree felony. Now, obviously very different. This isn't quite an enhancement. The counts in the state's information are charged identically, which I understand. But I think this is a narrowing of the transferred intent doctrine, which is useful. I think, again, it's kind of, it's showing that we're evolving and that, like, again, that transferred intent doesn't always fit certain situations. And I think that's what this case stands for. It stands for it doesn't fit. And just because it can apply, it doesn't mean that it should. And so I mean, absence of or mistake or accident, those are defenses. Those are valid defenses. And I don't think that we have enough evidence to support that this was intentional when it came to Aaliyah. He said over and over again in his interview with Detective Gentry that he did not intend to capture Aaliyah. That was not his intent. And so, again, I think for those reasons, and for what's been presented here today, that there's not enough to substantiate count 3 and count 2. And then again, I'll review my argument as to count 1.
All right, thank you. Ms. Devlin?
Your Honor, and as far as this kind of transferred intent argument goes, that entire line of argument rests on the fact that we must take as the truth, the whole truth, and nothing but the truth, what the defendant told Detective Gentry, not considering anything he had any biases, any reason for not telling the whole truth, not telling his whole motive, anything like that. So when we're thinking about that argument, we also have to start there with that premise that what the defendant said is the absolute truth. The state does not agree with that, as I've said before, but I guess starting from that point, we're talking about transferred intent. I think Ms. Leslie pointed out what I was going to say. I reviewed this case and some other similar ones last night. I agree that we can't necessarily enhance it if he, intended to hit another student, hit a school board employee, or I saw another case if he intended to hit a normal person and hit a pregnant person. You can't enhance that to an aggravated battery pregnant person. But that's not the situation here. The two counts between AA and Melanie Ames were charged exactly the same statute, exactly the same thing, so there is no enhancement there. So I would ask you to, again, continue denying on that grounds. As far as the phone itself, I think.
So going back just for a second,
Yes, sir.
if, for instance, it was a separate offense to commit video voyeurism on a minor, or as it actually is a separate offense to collect or transmit photographs of a minor, then the transfer intent would not work. Assuming for a moment that arguing that I'm believing their side. It's limited in this case. In this case, you charge the exact same statute. There's no minor enhancement or anything like that.
That's correct.
I mean, look, is there even a minor enhancement?
There's a different charge that the state can charge, I forget which subsection further in the statute, for a parent or custodial authority. Off the top of my head, I don't believe that there's a separate one for a minor, because I frankly probably would have charged that.
Okay.
I think it's just a parent or custodial authority, and then I think we would start looking at some possession of child pornography or manufacturing child pornography charges, otherwise.
All right, thank you. Go ahead.
Then as far as the cell phone, Your Honor, or the two-way communication device, I'm not going to harp on this one too much. I think we addressed yesterday again that the phone that Mr. Lynn had that has been entered into evidence is a two-way communication device. I think by the clear plain meaning of that statute. And there's plenty of evidence that the state provided that Mr. Lynn had used his phone in order to connect to that camera, to connect to the GPS device, to see what was going on the camera, see where Melanie Ames was as she was traveling in her vehicle, listen to her through both devices, and that he used that two-way communication device, that cell phone, to facilitate those felonies of video, or the felony of video voyeurism. I think the distinguishing factor here again, I made my argument yesterday about the Blackburger test with regards to use of a two-way communication device and traveling to a minor and solicitation. I think Ms. Leslie said that those are usually paired with traveling because they hinge on communication, but as the courts have said, they may be paired together, but they can't both be charged. The court pointed out in that White's case where the second DCA clearly said that there are differences between the elements, and thus it does not, the two-way communication device does not need to be subsumed within video voyeurism, it's not subsumed that they're different charges. Again, this video voyeurism crime can be committed without a two-way communication device. More often than not nowadays, yes, everyone has smartphones, cell phones in their pockets, but it still could be committed on a digital camera, an old school recorder, any sort of other way that this crime could be committed. So for those reasons, Your Honor, again, I would ask that you deny the defense's judgment as well.
Anything else, Ms. Leslie?
No, not to that. Thank you.
All right, I'm also going to deny this renewed motion for judgment of acquittal. Again, the issue on the transfer, on the intent, with regard specifically to AA, is the notion of transfer intent. And I don't find that the SG case or the exception there would apply. With regard to the cell phone, it was specifically used as an integral part of. It's an interesting. It is a very interesting argument that the defense makes, but in this particular case, the cell phone was both used, at least according to the evidence the state has submitted, that would caused me to have to go back and cogitate on this, was used both to facilitate as in setting up the cameras, but also to track with the GPS device. So in both of those cases, counts 1 and 2, cameras, as I mentioned earlier, have an integral a storage capability, which is separate from the transmission to the cell phone capability. And with the GPS device, it is facilitated. In fact, it's almost useless, I presume, I don't know, we didn't hear any testimony on it, without the cell phone being attached to it. So I think count 4 is integral to the other ones. I'm gonna have to think harder about 3 and 4. But in any regard, yes.
May I make one more update? I just thought about it as the floor was talking. Count 3, the installation of the tracking device, that is actually only a second degree misdemeanor, so for purposes of count 4, that, I guess that those actions by the defendant, would not qualify for the.
That's true, it's placement is the crime, it's
Right,
not
and
the using it.
The second degree felony, or second
Secondary
degree
misdemeanor.
misdemeanor.
All right,
So
thank you.
I
Yeah.
will withdraw my argument on that.
All right, so it's not tied to,
Correct. Thank you.
all right, are you both prepared to argue then?
Yes, Your Honor, I just need a moment to set my laptop.
No problem,
May I go ahead and do that?
you can do that.
May I, approach the clerk, Your Honor?
Yeah.
Will you please, swear?
You may proceed.
Your Honor, what you heard over the last day is that on Friday, July 17th, Ms. Melanie Ames was getting ready in her bathroom. Her morning started off normally. She had coffee on her back porch. She sat and chatted with the defendant, and she went inside and got ready. She took a shower. She began getting ready for work. And while she was putting on her makeup and getting ready, she noticed a towel out of place in her bathroom. She picked up that towel to put it back in the silver bucket that we saw, and that's when she noticed the recording device sitting on the bathroom counter. She didn't know what it was, and she got a work call, so she put it away until she had a moment to look at it. During that time, she didn't call out, she didn't scream, she didn't let anyone else know what was going on. She wasn't even totally sure what she had found. But what happened is that in the meantime, the defendant, Jason Lane, came into her bathroom and reached for that very same spot where he had put that camera recorder. And Melanie Haynes asked him, "Are you looking for something? Did you miss something?" At that point, Ms. Ames told you that the defendant got upset, started apologizing, said he was lonely, and he was sorry for what he had done. Ms. Ames told you that the next morning she and her two daughters spent hours reviewing videos on that device, and they didn't even make it through all of them. Ultimately, this case ends up with the Putnam County Sheriff's Office, who continues the investigation from the Crescent City Police Department, meets with Ms. Ames and meets with the defendant, who ends up admitting to placing the device, the camera, covering up the red recording light with black electrical tape, as well as placing the tracking device in Ms. Ames's car. We're talking about the charges that we have today. We have 2 counts of video voyeurism, 1 count for Melanie Ames, 1 count for Leah Ames, the installation of the tracking device, and the unlawful use of a two-way communication device. We're looking at the first element. I kind of broke it up into a few different sides here, Your Honor, because it is, for one element, I think it's got a lot of meat to it, and obviously it's one that we have been talking about here a lot, that Jason Troy Lane intentionally used or installed an imaging device. How do we know that Jason Lane did that? We have direct evidence of that. We've got Jason Lane on video. These are screenshots from videos that the court viewed yesterday, but we have screenshots of the defendant installing the camera in various places in Miss Ames's bathroom and bedroom over a period of 2 weeks. We have in the first one on the left side of the screen, the defendant installing the camera in Miss Ames's bedroom. Miss Ames told you that she had like a potted plant or a floral arrangement, and that's where the defendant had hid this first one. The second view is the defendant hiding the camera in Miss Ames's bathroom, which is ultimately the spot where she discovered it. In the third view, we have another opportunity where the defendant is installing the camera from a higher vantage point in Miss Ames's bathroom. It's clear from the camera alone that the defendant is the person that is setting these up. On top of that, we had the defendant's statements to Detective Gentry. He admitted to placing the camera in Melanie's bedroom and bathroom. Detective Gentry told him that he had put it in multiple places in the house, and he agreed, didn't deny that. Additionally, we have the fact, as I've already mentioned, that the defendant appeared in Melanie Ames's bathroom within 15 to 20 minutes of her discovering that device. Again, she hadn't screamed out, she hadn't texted him, she hadn't told anything about that. So what does that tell us? That tells us that the defendant was watching Miss Ames in her bathroom in real time and knew that she had discovered that device and came into the bathroom to try to find it. Second part of element 1 that I've broken up is to secretly view, broadcast, or record Melanie Ames. First of all, we have Mrs. Ames' testimony that she didn't know that she was being recorded at any point. Second, we've got the placement of the device, these hidden locations that were hard to see. On the top right, we've got that image that Miss Ames told you she kind of recreated. She couldn't remember if the camera was inside the towel roll or underneath it, but she wanted to document what it looked like when she found it. So she put it back and took that picture of it with her cell phone. The other camera screenshots that we have here, again, that screenshot where it was hidden in the plants, working from right to left. The screenshot in the middle on the bottom is on a floor vent in Miss Ames's room, facing her bed. And then the last one, again, that actually a camera angle on the bathroom counter. All of these were secret hidden places designed to block the camera from Miss Ames's view so that she didn't know it was there. What else do we have? We have Mrs. Ames's reaction when she found that device. Your Honor viewed that video yesterday. Again, we didn't play that publicly, but her reaction, it was shock, it was surprise. She clearly had no idea what it was in that camera, and she told you that on the stand, that she didn't even realize that it was a camera when she first found that device. Looking at to view, broadcast, or record Melanie Ames, it's clear from State's Exhibit 8A that SD card download, it's clear that Melanie Ames was recorded. There's tons and tons of videos on there, and there's videos of Miss Ames on that card, recorded to that SD card. We know that the defendant was viewing that in real time or at some point because he told Detective Gentry that. He said he would watch it in real time, and he showed up in the bathroom when Melanie found the device. So we know that he was viewing it. We know that he was recording Miss Ames. The state is only required to prove one of those. The last part of the first element, that the defendant was doing it for his own amusement, entertainment, sexual arousal, gratification, profit, or for the purpose of degrading or abusing Melanie Ames. The direct evidence that we have of this is from the defendant's interview. He told Detective Gentry that he was doing it for closure. He wanted to figure out if Miss Ames was cheating on him, and if there was some sort of other relationship going on. The state would argue that that alone is enough to meet this portion of the first element, that would fall under the defendant's amusement or entertainment. It may not be what every person in the world would consider their amusement or entertainment, but that's how the defendant was entertaining himself. That's what he was doing in his free time when he was watching these videos.
Objection, that's not evidence.
It's a suggestion, it's not evidence.
The statement of the facts then.
No, it's not, it's a state's, I understand what the state's saying, it's not evidence, you're correct.
I would argue that, Your Honor, there is at least, again, evidence that the defendant was watching it the morning that Miss Ames found the device, because again, he showed up in the bathroom without her informing him that he had found that device. So there is evidence that at some point he was watching it. Again, the location of the videos, or the video recorder device, that he put this video in Miss Ames's private bedroom and bathroom. There was some talk back and forth about when this relationship ended. Was it ongoing? Were they picking up on and off? Miss Ames was very clear on the stand that that was not happening. She was also very clear that they had a very amicable relationship, that they got along, that they stayed roommates, they watched TV together in her bed. She was very forthcoming about all of that, but she was clear that there was a definite change in the relationship in approximately January 2020, sometime before the COVID outbreak began, and that at that point, their relationship was roommates only. Miss Ames's daughter was very clear about that as well. The defendant, in his interview to Detective Gentry, said on at least two, I believe 3 different occasions, that it was her room, her bathroom. Those were the defendant's words. He didn't say our room, our bathroom. He described those as hers. The period of time. This first video that we have that captured Melanie Ames was on July 9th. But the recordings on the download started sooner. So again, the fact that he had been trying to capture these videos for a long period of time goes towards, again, his amusement, entertainment. At this point, Your Honor, based on the location and the amount of time that he was doing this, the fact that he was moving the camera around so often, the state would submit that the defendant was trying to capture more than just Melanie walking in and out of her bedroom and bathroom. He was trying to capture those images of her changing and nude. The fact that the defendant exposed himself on camera and was masturbating mixed in with these videos. He wasn't just looking around, seeing what was going on, and trying to figure out if he could catch Melanie cheating on him. That may have been part of it. But there was also a sexual element to this as well, evidenced by his own actions on camera. If it was truly for closure, he could have installed a listening device or turned the camera where it would not have captured images of Melanie. But he didn't do that. He turned the camera to make sure that it was facing areas where he could capture Melanie as she was coming and going. The second element, that Melanie was viewed, broadcast, or recorded at a time when she was dressing, undressing, or privately exposing her body. We know that from the SD card download. She was recorded. We have those videos. They've been entered into evidence. Detective Gentry told you that she reviewed that entire download and found 13 separate video clips, 4 in the bathroom, 9 in the bedroom. There's no requirement in the statute that there be multiple viewings, recordings, or broadcasting. That's why the state charged a date range in this situation, as opposed to charging a separate count for each one. Some of these, the court may recall from viewing yesterday, were on the same date and time. We heard testimony that these would save in 30-second clips. So even if Ms. Ames was in the bathroom at one time, which we saw at sidebar on 2 separate videos, there were clips back to back of Ms. Ames at a time when she was dressing, undressing, or privately exposing herself that were split up into various clips because of the way this camera recorded. So when we consider that, that's not 13 distinct times that Ms. Ames was captured. It's far less than that. Of the 15 videos that the state showed you yesterday, I believe 5 of those were Ms. Ames over 2 different occasions, for example. State's Exhibit 4, videos of Melanie in her bedroom and her bathroom. Again, what I've been discussing. This was a clip from one of the videos that Your Honor viewed yesterday, where Ms. Ames had walked into her bedroom to change and put on a pair of shorts. We know she was captured at a time when she was dressing, undressing, or privately exposing her body. We also have the defendant's statements from his interview. The fact he said he paid an extra he paid $160 for a device that he was able to watch live. And he stated he watched it live, that he viewed it. The third element of count 1, that Melanie Ames had a reasonable expectation of privacy. And the standard jury instructions define that to including but not limited to the interior of a residential dwelling and a bathroom. Here in this case, the videos in question were taken in Ms. Ames's bedroom and bathroom. And the state has again provided more clips of those, which were from State's Exhibit 2, Composite Exhibit 2. Fourth element, that the viewing was without Ms. Ames's knowledge and consent. Ms. Ames told you that. She told you loud and clear that she didn't know that this was happening. She didn't consent for the defendant to film her, and frankly, she didn't want to be filmed. Again, it's clear from that last video that the state showed on Exhibit 4, on the video exhibit yesterday, that Ms. Ames did not know that that video camera was there when she found it. That was State's Exhibit 4. Element 5, the defendant was 19 years or older at the time that he committed these crimes. During his interview with Detective Gentry, he said his birth date was August 15th of 1979. And Ms. Ames testified that she thought the defendant was approximately 40 years old, that their families had known each other since they were kids. That element is pretty clear in and of itself. Count 2, video voyeurism with respect to Aaliyah Ames. Again, I broke it up similar to how I broke up Miss Melanie Ames. One, that the defendant intentionally used or installed an imaging device. Again, we've got those same screenshots from State's Exhibit 4 of the defendant installing the device in the bedroom and bathroom. And the fact that he appeared in Miss Ames's master bathroom within 15 or 20 minutes of her discovering that device, again, goes to the fact that he was the one that was using or installing this imaging device. Second portion of this, again, I broke it up the same, to secretly view, broadcast, or record AA. We have Miss Ames's testimony that she didn't know that she was being recorded. Again, we've got the placement of that device in surreptitious locations throughout Miss Melanie Ames's bedroom, and then the shared bathroom that the two women started sharing as soon as the relationship between the defendant and Miss Melanie Ames ended in approximately July of 2020. Miss Aaliyah Ames was very clear about the fact that this was the only shower that she used, the only bathroom that she used once that relationship ended as far as getting ready to go. So that's our evidence as far as the secret part of it. To view, broadcast, or record AA We've got, again, that placement of the device, the SD card download states Exhibit 8A. He admitted that he knew it was recorded to that SD card. He said that twice during his interview. And the defendant's statements during that interview that he was viewing the recording in real time. The last part of element 1, again, his intent for his own amusement, entertainment, sexual arousal, gratification, profit, or for the purpose of degrading or abusing AA. Again, the defendant during his interview, he says that it was for closure. It was related to Melanie. It was to figure out why that relationship had ended 6 months before was his reason. But we need to look beyond that. Again, the circumstantial evidence, the location of these videos, the private bedroom and private bathroom that Miss Ames slept in, and the bathroom that both women shared, the sole bathroom that Miss Aaliyah Ames used as far as getting ready from the time that her mother and the defendant broke up. Now, there was testimony again that if someone was closer to one bathroom here or there, they would use that just for purposes of using the restroom. But for purposes of getting ready, Aaliyah was clear that she only used one bathroom. The defendant exposing himself on camera and masturbating. Again, that is very, very important here, Your Honor. We're thinking about that. The defendant captured Aaliyah in a towel, look at the time, on July 15th, 2020. That's the date that she was captured walking into that bathroom. If this was truly about just capturing Melanie Ames, he should have stopped on that day. He should have stopped when Aaliyah was captured in that towel, turned the recording device around so that it only captured the audio, and not continue. But what did he do? We see Aaliyah walking in that clip into the bathroom on July 15th. What does he do? By July 16th, the second clip that I've posted on here, the defendant has moved the camera from the bedroom to the bathroom, to the place where Aaliyah went. If this was not about capturing both women, if this was just about capturing Melanie, he wouldn't have done that. He wouldn't have made those actions. So when we look at the defendant's actions on where he placed the camera, that is the strongest evidence of what his intent was. He placed the camera where he saw Aaliyah go. Now, he wasn't successful in capturing Aaliyah again, but that's what he tried to do. And again, this charge does not require more than one photograph, more than one recording, more than one broadcasting. It just requires that the defendant did it once. So the fact that he was not more successful does not mean that he's not guilty of this charge. Again, this is an escalation of the behavior. This is a clip from July 16th, the day after Aaliyah is captured in that towel, and the defendant is in Melanie's bathroom, the shared bathroom for these two women, exposing himself and making sure that you can see from the chest down to the waist, below the waist when you're getting out of the shower, and what you can see from this angle. This is an escalation after we see Aaliyah captured in that towel. Also, when we're thinking about intent, think briefly to the testimony of Krista Carroll. Her testimony about what happened to her contradicts the defendant's innocent explanation of how Aaliyah's recording was captured and how Melanie's recording was captured. And the more frequently that an act is done, the less likely that that act is innocently done, and the less likely that that was done with innocent intent. And that is
But that's propensity evidence, I'm not going to consider that.
Your Honor, this was pulled directly from Earhart under intent.
Okay. As to intent, maybe, but when you talk about frequency and likelihood, that's exactly propensity. Go ahead.
Not regard to propensity, but regard to whether the act was innocently done, whether that intent was innocent as the defense has claimed, or whether that act was done for his own amusement, entertainment, sexual arousal, gratification, profit, or for degrading or abusing AA. That's what the state is arguing here, going towards that point. Next, element number 2, that AA was thereby viewed, broadcast, or recorded at a time when she was dressing, undressing, or privately exposing her body. Again, we know she was recorded from that SD card download. Detective Gentry told you that she reviewed that video, and that there was the one recording in a towel walking into the bathroom. Again, there is no element in video voyeurism that requires multiple recordings, multiple broadcastings, anything else. The court viewed that video of AA walking into her bathroom in a towel. And again, the defendant said he paid $160 to be able to watch that live, to be able to view it. Count two, element 3, that Aaliyah Ames had a reasonable expectation of privacy. Again, the interior of a residential dwelling, the bathroom, we know that her recording was taken as she was walking from her mother's private bedroom, her bedroom, even as the defendant says, into the bathroom in a towel. The viewing was without her knowledge and consent. Again, Aaliyah testified that she did not know that this was happening and that she did not give the defendant permission to record her. And the fifth element, the final element, the defendant was 19 years of age or older. Again, he gave his date of birth in his interview, and Miss Ames, Melanie Ames, testified that he's approximately 40, and they've known each other for a long time. Count 3, installation of the tracking device or application. This count, Your Honor, if I recall, they're not standard jury instructions as far as this count goes, but that the crux of this is whether or not the defendant knowingly installed a tracking device or tracking application on Melanie's property without her consent. We have pictures of where this device was found. It states Exhibit 3, Composite Exhibit 3. The first photo on the right, which states Composite 3A, that is the photo where that tracking device was located in Miss Melanie Ames' car. She testified that she had just gotten that car. It was a brand new vehicle. She had owned it for a few weeks, and that she had never seen that tracking device before. We also have 2 other pictures of the tracking device, as well as the photo of the box that it came in. And going through that again, how do we know it was the defendant? The packaging. The final photo of State's Exhibit 3, State's 3E, was a box delivered directly to Jason Lane, and that's where these GPS devices were found. The GPS box, the empty boxes were found, or the empty box and the one for the second device was found in the defendant's closet in the guest room where he was staying. Then Melanie testified that this was a brand new car that she had just gotten, and that she always hung her keys up on a by the front door on a little key holder, and that the defendant had access to that. The location of where the GPS was placed in the car was placed on that passenger side. It was placed in a spot where Miss Melanie Ames, as the driver, would not easily see it between the center console and the passenger seat. Finally, we have the defendant's confession when he talked to Detective Gentry. She hadn't even asked him about the GPS device, and he brought it up first. He said that he ordered it, he said he installed it, and then he even told Detective Gentry that it had audio features, and that he could listen to what was going on. And on top of that, we know that he actually, on top of installing it, we know that he actually used it because he said that he watched Melanie drive around the campground by Renegades 5 times and that he listened to her. So we know that Jason Lane was the one who installed this device. Count 4, unlawful use of a 2-way communication device. Cell phone is a 2-way communication device. This cell phone, this smartphone that has been entered into evidence as State's Exhibit 7, I believe. This cell phone is a smartphone device. The defendant testified that he purchased equipment that he could access from his cell phone. The GPS device and the camera recorder could be accessed from the cell phone. We know that this is a 2-way communication device. He did so for the purpose, and count the second element of unlawful use of a two-way communication device. We know he did so for the purpose of facilitating or furthering the commission of a felony, because we see him do it in real time. We see him in this video clip from State's Exhibit 4 that the court watched yesterday. We see his cell phone, this same black cell phone, sitting on the counter in the bathroom. And then we see the defendant step into the shower, peek back out at his cell phone, grab his cell phone, and look at it while he's standing in the shower, getting in and out of the shower. We know that video voyeurism is a felony, and we know that the defendant was making sure that that camera angle was at the proper angle to capture somebody getting in and out of the shower at that time. Your Honor, this is direct evidence of count 4. And the state believes that it has proven its entire case, all 4 counts beyond a reasonable doubt, and the state would ask that you find the defendant guilty as charged. Thank you.
Defense?
Judge, may I have a 10-minute recess, please?
Sure. We can do that. Take 10-minute recess then.
Thank you.
You're welcome. you ready to proceed, Ms. Leslie?
Yes, but at this time, I have some concerns. I did not make a, contemporaneous objection to the state's comment earlier, and I think the judge caught it. I had actually highlighted it, written it down, but he caught it before I did and wanted to place an objection on the record. I think that's a very important issue, so I kind of want to litigate that a little further. If you could before proceeding, because there might be motions I need to make. I didn't hear the beginning part of what was said, and if that was in conjunction with the Williams Rule evidence, or if that was just pertaining to this case. I don't know if it would be permissible to ask the court reporter for exactly what was stated on record before that, so I could potentially argue.
We can certainly ask the court order to read it back.
Could we do so, ma'am?
What part are you talking about?
Right before the judge interrupted the state on closing, what was the state's statement? He would have said propensity evidence.
Is when I mentioned the name Krista Harrell for the first time. So,
Okay, tell me one more time now.
Either would have been when the judge said propensity evidence, or when Ms. Devlin said, Krista Harrell.
So you want the statement right before when she said that for the judge?
Yes, please.
Okay. She said, also, when we're thinking about intent, think briefly to the testimony of Krista Carroll. The testimony about what happened to her contradicts the defendant's innocent explanation of how A's recording was captured and how Melody's recording was captured. And the more frequently that an act is done, the less likely that that act is innocently done, and the less likely that that was done with event, and that is what, and then the judge says that's propensity evidence, I'm not gonna consider that.
Judge, based on that,
Okay,
may I
hang on just a second, I'm gonna get back to the machine.
thank you. Judge, based on that, I would like to place argument on the record as to that. I know you're not considering it, but I do have concerns of kind of what that means for the Williams rule evidence that came into the trial in and of itself.
Go ahead.
Judge, I believe that the state did say that this quote does come from Earhart, which I agree, I found it. The case that references it actually specifically quotes it more frequently. An act is done, less likely it is innocently done, comes from Jensen v. State, 555 Southern 2nd, 414, page 415, Florida 1st DCA 1989. In that case, it would appear that that evidence that they used was different in that there was a voluminous number of instances. The state was seeking to enter evidence of 8 prior burglaries of the same victim's house were admissible to show the defendant's intent. You have 2 instances, and specifically Jensen's analysis of allowing that reference or that argument comes from the specific number. They do analyze that was a specific number, that was a higher number. Having one other, again, I don't think it warrants that argument, and I think that's highly prejudicial. And again, I think my concern is going forward. That was obviously we don't have a playbook of what the state's arguments are going to be at trial until we get here. But if that was what they had intended to use that evidence for, then Krista Harrell's evidence should not have come in. And for those reasons, I would ask for a mistrial.
State.
Your Honor, again, those 2 quotes from my closing argument I took directly from Earhart's section on intent, because
Which section, please?
my copy, and again, I'm looking at 2012, but it's 404.12, evidence of other crimes, wrongs, or acts. This is specifically under the intent. I'm sure our page numbers are different.
Okay.
Mine is approximately the second full paragraph starts out with evidence of similar acts that contradict an innocent explanation of the defendant's act is admissible. And then it's got, mine is a headnote 4, it talks through that, cites too many cases. Then the next sentence is the more frequently an act is done, the less likely it is innocently done. And then I look again, quotes to headnote, or footnote 5, I'm sorry. And specifically where I got the second part of the quote from my closing argument was from that Jensen v. State. So that is why I stuck specifically to those 2 sentences. I believe the court did go through the analysis, well, not believe, the court did go through the analysis already, made its ruling on the admissibility of the Williams rule, and in its order said that the Williams rule was specifically admissible for intent. So that is where I focused my argument. And that is why, again, I clarified that my argument was not that because it happened before it happened again, it was that take this prior incident and it contradicts his innocent explanation. It goes to that innocent explanation because thus far that has been the defense that the state has seen presented through cross-examination, is focusing on the fact that this was done to console him, to figure out why Miss Ames and he were no longer together, or she was cheating on him. I can't think of the exact word that is used at this moment by Detective Gentry in her interview, but that has been what the defense has been harping on in its cross. So that was my focus for my closing, again, based on the court's ruling that it was admissible for intent. And again, that's why I stuck directly to the quotations from Earhart and from the cases cited with those footnotes.
May I respond?
You may.
Judge, I think that just impermissibly stacks bad acts against bad acts. I think that's not being used as the state's intending to. And I think Jensen is a very specific case with a very specific set of facts, and I think it was useful and I think it made sense. Same victim, same defendant, 8 cases. If another case comes in, yeah, it's probably more probable, and that was more probative at that time because of the specific facts in Jensen. We don't have that here. And I would still stand by the fact that that's very, that just shouldn't come in, because it sounds like the only reason that the state has used that now is to prove propensity and nothing else.
All right, with due respect to Professor Gerhardt, I probably would not have used the words that he used because, as I said in my original comment to the state attorney, it sounds like you're hinting towards propensity. I do see the purpose that he offers in his treatise. I see the reason the state has offered it. Again, I'm going to say I'm not going to consider it as propensity evidence, so I don't find that it's prejudicial because I'm just not going to go there. I'm going to overrule the motion for the mistrial, or deny the motion for the mistrial, and keep the objection on the record that I in fact placed myself, that I'm adhering to my prior ruling with regard to the proper use of that evidence. And I think I see where the state's argument's going. Perhaps more of a tip for future jury trials: don't go there in front of the jury. But I think we're fine here today. All right, you may proceed, Ms. Hudson.
Yes, Judge, I proceed with closing arguments.
Yes,
Will you
sir.
please the court?
Please.
Thank you. Mr. Lane is a very dejected man. This allegation of cheating was extremely difficult on him. And I want to talk about that and why that's so important. We talk about intent, and I know oftentimes, state doesn't have defendant statements to consider. But in this case we do, and that is the best evidence of intent. The state doesn't get to pick and choose what they like about what he said. It's what he said. Detective Gentry recognized it as honest, forthcoming. That's important. That's significant. What does cheating do? Cheating changes how people, even the allegation, thought that someone could be, a loved one that they care about could be cheating. It affects self-esteem, self-confidence. It affects people on a multitude of levels. The grief of a relationship. It's a very sad thing. I use the word dejected because it fits here. It's defined as sad, depressed, dispirited. Why am I spending so much time on that? Because it's important. We take people as they are. State wants to insert how they're viewing, or they want to view this incident and his intent because they want to make it fit a crime. But we're not taking Mr. Lane as he was. His intent matters, and where he was and what he was thinking at the time of his life matters. He was thinking he was being cheated on. Not only is he being cheated on, which is hard enough, but the woman that he loved and who had been in a relationship on good terms with for 3 years was cheating on him with his brother. Objection in the interview.
Continue.
That's horrible. That's absolutely, that's 2 blows. And so whether or not we believe that those beliefs were true, it's what he believed. I didn't ask Miss Ames if she'd been cheating. It's not relevant. But I will say there's some confusion about where they were in their relationship. And I think that's the place, and I know that's the place that Mr. Lane was coming from.
Objection, that's not evidence.
Sustained.
Miss Ames stated they broke up in January. Then she said it was 4 to 5 months. We work back, that's March. Then they were going to events in May together. Holding themselves out as a couple,
Objection, that's on evidence.
argument.
Overall, I'll allow that for argument. I know where the evidence where that comes from.
So, and again, they're staying in the same bedroom. They are,
Objection, that's on evidence.
Overall, there was evidence that they had been in the bedroom together. That's where I take it as.
they were falling asleep together, they were watching TV. Whether or not they were intimate, you don't need to have intimacy to be in a relationship. And in his head, if he was still thinking, we're working through things, or we're on again, off again, because of these things, that these events that they were going to, it's very confusing to be going through a tough time in a relationship and living with someone, and then having the allegations of cheating, and then having the allegations that it was with your brother. That changes your perspective. And so his intent was to get closure, to get confirmation. That's what he says over and over again. He put the cameras where he did because they were areas where she would go and use the phone. And he was trying to see if that's who she was talking to. That's what he says to Detective Gentry. The state says that the two elements, or the two specific intents that they believe they've shown, or that the videos were being used for by the defendant, were amusement or entertainment. And again, I feel like I have to go into the vocabulary of these items. Confirming cheating, the state claimed that was in fact an amusement or entertainment. The definition of amusement is finding something funny. The definition of entertainment is an action of being provided entertainment or amusement. This was funny. Confirming cheating was funny. He even comments to Detective Gentry in the interview that his brother was a piece of shit. Doesn't respect women. He was upset that that was the man she had chosen. That's where his intent was. It was to get closure. The definition of closure is acceptance. It's not amusement. Losing someone that you love and obviously cared for and lived with for 3 years, there's nothing fun about being in these relationships, going through tough times and believing someone's cheating on you. That's a stretch. That is a stretch to pull that evidence and make it fit that specific intent that wasn't here. I want to address this because I think this is an elephant in the room. I think no one likes the concept of cameras being placed in private areas of homes without someone's knowledge. I think we can agree that that's uncomfortable, perhaps even creepy. Creepy and uncomfortable are not criminal. Not in this case, not in video voyeurism. There has to be a specific intent. And the intent that the state has claimed that their evidence should prove is amusement and entertainment, and it does not. That is far-reaching. The state also claims that what he said, there's more to it, that's not the full truth. Detective Gentry found him honest.
Objection. Arguing about witnesses commenting on each other's credibility. He's asked on the cross, the full string.
Yeah, overall.
You take people as they come. His intent might not make sense to the defense or to the state, or it might be uncomfortable. But that's where he was in his life. This is, in the middle of COVID, there's stress, they're going through tough times. There's friendship, there's not friendship, there's these family events. These are tough times. That's where he was in his life. And he only wanted acceptance. The closure that the relationship had in fact ended, or to confirm the cheating allegation. That is absolutely just not used for the purpose of amusement. When going into analyzing the credibility of the witnesses we've heard here today, or yesterday in fact, I think Melanie's testimony, the parts about the relationship, I think is where she's not being 100% credible. Because she wants it to seem like there was that clean break, and I don't think there was that. Because again, if it was January, you remember January. It's the first month of the year, it's 2020, it was a rough year. We're gonna remember the 2 months that we had that were fun. January was one of them. The fact that it changes, those subtleties are important. It's because she wasn't sure, because the relationship was on again, off again. That's why. And I think because, again, doesn't make her, it's tough. And I think she wanted to make it, well, I'll move on. The evidence that the state has presented is a lot of what ifs. It's, well, he's doing this, he's doing that, what if that? And that's not accurate. Here's why. Mr. Lane repeatedly said in the interview that he hadn't watched the videos and he didn't even know that they were stored. Listening, maybe, sure, but he didn't watch them. He wasn't going back and he didn't know that they were on the SD card. He specifically said that in the interview. The fact that the state is assuming there's no evidence of that he was repeatedly watching these videos, and that's how he knew when Melanie was in the bathroom and she had found the video camera on the 18th. Well, that doesn't, or excuse me, the 17th. That doesn't make any sense because her testimony on the stand was, in fact, he came in looking for the camera. And she actually says to him, missing something? If he had known she had discovered it, wouldn't he just go right up to her? Why would he be looking for a camera that she had already discovered? It makes no sense because that's not how it happened. He wasn't watching. He went in to use the bathroom. Went in to talk to her. I mean, he had free range to go places in the house. That's a stretch. That's a complete assumption on the state's part, and there's no evidence to support that fact. A person can't be convicted on these what ifs. The law requires more. The law requires in these two instances specific intent. And the state hasn't proven it. Steve also argued, interestingly, that if his target wasn't Aaliyah, that he should have installed a listening device instead. I thought that was interesting because is that assuming that installing a listening device makes it no more criminal? But that in fact would, according to the state's theory. And then again, the reason that the tape wasn't moved, because again, the state's argument was that as soon as he discovered that Aaliyah was caught on the tape, which was the 15th, he should have stopped. The reason he didn't stop is because, again, he told Detective Gentry he wasn't watching them, wasn't viewing them. So if that's the case, then that makes sense. Then the lack of it stopping or it being moved around to, then that shows that he wasn't watching it, and that proves the defense's theory. Steve has an interesting point as to how or why those 4 clips, 2-minute video of the defendant exist. The state's theory is that it's a theory. This is not proven by any testimony. That is a complete theory. Detective Gentry didn't testify to that. That is the state's theory as to what he was doing, was that he was trying to position the camera so he could capture someone coming out of the shower, and that's why he was adjusting himself or lowering his pants to see if you could view the bottom half of a person. I mean, I think it's human nature. People examine themselves in the mirror. People walk by on the way to the shower and, okay, gained a little weight this month. I think that's common practice. And that video, he's I mean, not to point it out and be Captain Obvious here, but he's flaccid. He's not aroused. He's not, touching himself inappropriately. He's kind of just looking at himself. He's turning to the side. He's kind of just, checking himself out. Whether he's, I think that's common. That's not criminal. Nor does it make it some ill intent. Again, that's an inference. That's a what if. That's the state's impression of that. That's not anything that came directly from the stand or for evidence that the state or that the court could consider. And then masturbating. There were no explanations in detail. The video wasn't submitted. There was no explicit detail from Detective Gentry that was elicited from the stand with regard to the masturbation. She doesn't know him. She's never seen him. She doesn't know what he looks like, whether he was erect or not erect. Nothing, no testimony of that. I come back over and over again to the statement. I know I've said it. I'll say it probably a few more times to nauseam, but we take people as they come and as they are. And understanding a little bit about Mr. Lane at the time when this all was, it matters to go to intent. And it does, I think, strongly support the theory that the defense is presenting and negates a lot of what the state is interpreting. Or wants to interpret from the evidence here today and presented. I think the analogy, similar situation would be children. Children, you're afraid of the dark. Nothing in the dark that can hurt you. Your TV has, I don't know, might look weird in the dark, but it's there. It exists and you're afraid of it. And we all know that's a misguided belief and they'll grow out of it. But they have it. It doesn't, they believe it. And I think that's what's important here. Mr. Lane believed she was cheating. That's where the intent came from. And it came from he believed she was cheating. And he needed that confirmation, that closure. The other thing is, the interview, again, he makes admissions. I mean, there are things that he does admit to. Why admit to certain things and not others? I think he strongly, again, denies that the intent was not Aaliyah. Again, he goes on and says, I love those girls. That was not his intent. He says that over and over again. And then you also have to look at how this has been charged as a whole. It's the GPS device as well, which was specifically placed in Melanie Ames's car. If Aaliyah was the target or the intended party, or he had some type of interest, specific intent interest to follow or voyeur her, he would have put a listening device. He had two. Actually, he had two devices. He could have put one in her car. He didn't. Which again supports the claim that the defense has been making that he was trying to catch or gain a confirmation that she was cheating and get that closure. Because that's what he believed. The other thing that the state's mentioned is in the video where the defendant is in and out of the shower, he has his phone. There's no idea what he did on the phone at the time in that video. The state can speculate all day long, but there's no direct evidence of what was done. Again, I think to consider that as anything, or to show that, oh, he was looking at himself, he was positioning himself, we don't know if he was checking an email or a text. I mean, that's complete speculation. Again, this phone, the way it acted, it's not a two-way communication device. It acts as it can be one, but it was not used as one in this instance. It was a server, it was a hub, it was where these devices were linking to, but there was no communication from the phone to the device. And I think the biggest analogy I can draw and present to the court is a Ring camera. Again, you can communicate with a Ring camera. Your phone can directly act as a communication. You can talk to the device and talk to the person standing in front of the device. That is a two-way communication. That's using a two-way communication device. We just don't have that here. There's a break where these are one-sided machines, and again, just because the phone was the hub or the server where this information was stored, I still don't think means that it is being used in the intended purpose as a two-way communication device. Two things with regards to facts I want to highlight for the court to take into consideration in the call when considering a verdict in this case. One, I don't believe that the girls shared a bathroom, that Aaliyah and Melanie shared a bathroom. And the reason I say that is because there would be more videos, and there aren't. And I think that just doesn't make sense. And I don't think, again, if Mr. Lane was using a bathroom, again, that bathroom, she even said, Miss Melanie Ames said that the bathrooms, the way the house was laid out, that the 3 bedrooms were by the guest bathroom. It would make logical sense. In the middle of the night, you think that Aaliyah is walking all the way down the hall to her mom's bedroom, walking through her mom's bedroom to that door to go to the bathroom. It's not happening. Obviously, she's getting undressed. And then the one video that we did see, she comes in briefly, her hair in a towel, indicating that it was already wet. So what does that mean? That means that she had showered someplace else. She was coming to that bathroom as I asked her, you're just getting a hairbrush, you're just grabbing makeup, whatever she was doing. But again, they didn't share a bathroom. And Again, I think the state has tried hard to make the evidence fit the conclusions they want it to fit, but that's not what the evidence directly that came from that stand shows. Both Aaliyah and Krista testified, or it was evidence that was presented, that they never felt uncomfortable, weird at, vulnerable. And I think Krista's, referred to him as her dad, even after their breakup, would still, even though that's not her biological father, would still share time with him. Never felt uncomfortable spending weekends alone with him. That was the whole point of why they were together. State's argument that the behavior was escalating because the video with him exposing himself was the 17th and the Aaliyah video was the 15th, or excuse me, I think the video with him was the 16th, sometime after Aaliyah. Again, the evidence came from the video, the interview with Detective Gentry, that he was not doing that. And that's evidence that the state presented. It doesn't fit their theory. And if the states, they also go on to mention he was testing what could be seen. Why wouldn't you have seen him do that sooner? You see him making the positioning the cameras, and then there is footage from an earlier date captured of Melanie. And obviously, there's nudity that can be seen on that. So he had been successful. So to say that what the state's trying to say is that he was escalating, he was trying to get a better angle, he was doing this, he was checking to see if everything could be seen. Well, if he had been watching the videos, he would have seen that it was, and that it was working. But he wasn't doing that. State's always going to come. I know the states obviously have the opportunity for a second opportunity to speak with Your Honor, and they're going to come up, and I know that they're going to remind you that a reasonable doubt is not a mere possible doubt, speculative or imaginary or forced doubt. Is a reasonable doubt. What I'm asking you to do is to listen very closely to what the witnesses have said, and not place the inferences that the state is wanting you to make on them. Because what they have said, contradictions, ever so slight, are significant. And these aren't things I'm asking you to imagine. These are firm things that came from the witness stand. In fact, one of the big things that I'm asking the court, pleading with the court to consider, is the interview, state's evidence. His own words. That is the best evidence of intent. We often don't get it, we have it. Why discard it? Because it doesn't fit what the state wants it to fit. That's the evidence for you to consider. To emphasize what hasn't been proven, made into the record, or given as and offered as any piece of evidence, is these videos were later uploaded to the internet anywhere. These videos were not repeatedly viewed. There's no evidence of any further action that was taken in congruence with these videos. I think if that evidence had existed and the state had proven it, they might have had an easier time proving the specific intent, but there is none to consider. One of the things I do want to point out, again, it's worth mentioning, there is a statement in the interview where Mr. Lane says, yeah, I know it was wrong. And I don't want the court to consider that as an admission or an acknowledgement of his intent. It's not. Admitting I can be wrong about something, still admit it, doesn't make it criminal. Proving intent is different. This might not have been the best idea. This might not have been the best way of confirming cheating. What's interesting, though, is some of the methods, cameras, listening devices, those are things investigators, private investigators would use in marriages when they're hired. The blinds are open, which in some of the still shots that the state's presented, the slider window that's in the master bedroom, the curtains are open. If a private investigator had stood outside, and in some of those videos where Miss Ames is undressing, there's visible light coming in through those windows. If a private investigator had stood out her window and taken a photo, and caught her with another man, would we have been here for video voyeurism? Overall, the state's evidence is weak. It's not strong. They're trying to make things fit that don't. I want to remind the court that a reasonable doubt is beyond, yeah, maybe he did it. Yeah, he could have done it. He probably did it. You have to prove that the state has to prove that he actually committed these acts. And further, because of the law, because of how these statutes are specifically written, he has to have specific intent. So you not only have to agree that the state has proven that he's done it, that he has committed these offenses without a shadow of a doubt, that he intended to do them in the manner that the state has described, which they have, in theory, based on their argument, abandoned the others and only stated amusement or entertainment, which do not fit. There wasn't a profit that was made. Again, these were placed not on the internet. These weren't shared. He didn't benefit. Gratification, not done. Closure and gratification are different. Again, closure is acceptance. Gratification is pleasure. Pleasure is pleasure in finding out someone's cheating on you with your brother. His demeanor, the way his voice went up in that video would show that he was angry. Not that he was seeking pleasure from any of this. Demeaning or abusing. The evidence of demeaning or abusing, I think, would go towards more of if he was using this as blackmail, to taunt her, to show her next boyfriend, show his brother. That wasn't going on. There's no evidence of that. He wasn't embarrassing her with this information by posting it or sharing it or even telling the daughters about it. He wasn't doing that. Sexual arousal. Again, the video that the state did show does not show him erect. There's no arousal. Visibly, there is no arousal. There was no description that came from the stand. Masturbation can be interpreted differently.
Objection. There were facts and evidence.
I'm sorry?
There were facts and evidence related to the masturbation.
And
Can I comment on that? The objection?
go ahead.
My understanding from the evidence presented is when asked about that, Detective Gentry said that he masturbated. That was it. But we didn't go into the details of what she saw to make that interpretation. There's no evidence of specifically what was being done. She's never seen him nude.
Nor did you explore it across.
So I'll take it as commonly used in the term.
Let's proceed.
The state has not met their burden. I will say it again. We take people as they come. Mr. Lane was a dejected man, sad, finding out and breaking up, and learning that the possible reason for that was cheating with a family member. That's the place that Mr. Lane came from in this case. And again, his intent was pure in that sense. That's where he was coming from. And it is no more complicated than that. And for those reasons, the defense would ask that all charges, that he would find not guilty. Thank you.
State rebuttal.
Yes, Your Honor. Before I go into rebuttal, I would like to ask the court to reconsider its ruling on Williams' rule based on Ms. Leslie's argument. I believe that Ms. Leslie made arguments with reference to Aaliyah, specifically that this was a mistake, that his intent was to capture Melanie to get closure on cheating, and that if Aaliyah was captured on that video, that it was a mistake. So at this time, based on the argument, I would ask the court to reconsider its ruling.
Say that again. I didn't follow you.
Yes, sir. So the court made its ruling that the Williams rule for Krista Harrell would be admissible for intent. During Ms. Leslie's argument, she stated that the defendant placed this video recorder for purposes of closure to catch Melanie Ames in conversation with another man cheating on her, whatever it was, so that he could have closure. And that capturing Aaliyah was, I don't believe she used this word specifically, but I believe her argument implied that it was a mistake because
She said accidental.
Okay, so that it was an accident that he intended to capture Melanie. So for that reason, I would ask the court to expand its ruling, and I'd be able to argue during rebuttal Williams' rule in reference to lack of mistake.
Ms. Leslie?
Because of the JOA arguments, I have argued intent and lack of intent. Even again, and as the courts informed me, again, the transferred intent doctrine, again, it's all based on intent. The theory is that she was not an intended party. I've been firmly arguing a lack of intent. Even the motion for judgment of acquittal argued solely intent.
Right, but but you did argue that it was purely accidental, that the capturing videos of Aaliyah were by accident. And I think that there's a close relationship between the lack of intent and the notion of mistake under any circumstances. They're very close concepts together.
I would agree as I'm thinking of it. However, I still don't think that based on the facts from Ms. Harrell's case to the facts presented in this case are analogous on that particular element or on the mistake part.
Again, arguing more of an identity type, not identity as in who the person is, signature crime. I guess that you're arguing that it needs to be a closer match in order to to go to the issue of mistake and,
Right.
all right, I'll take that under consideration. I'm gonna allow Ms. Devlin to make the argument. And it's a very nuanced, this area of law is a tough one. But I will allow her to make it. Go ahead, Ms. Devlin.
We have 1 moment just to gather my thoughts on this one.
Please go ahead.
This was a dumb decision, and I deserve whatever I get. That is what the defendant told Detective Gentry in that interview. Melanie and Aaliyah Ames's privacy was worth $160 to him. That was the amount that he paid for that recording device that he could connect to his phone and watch live. The only person that lived in this alternate reality where there was some sort of romantic relationship between Melanie Ames and the defendant past January 2020 was Jason Lane. Ms. Ames was very clear about the change in their relationship. She was very clear about the fact that they became roommates. If she wanted to hide that from the court, why would she have admitted that they watched TV together in her room? Why would she have admitted that there were times that they fell asleep? Why would she have admitted that they went to family gatherings together? It's because they had been friends their entire lives. Their families knew each other. They began a dating relationship in July of 2017. She remembered the exact date, which I don't remember here today, but that was a happy day for her. That was an important day for her. The sad day, when the relationship ended, she didn't quite recall that, but she was clear that their relationship went from being romantic to being roommates. And Aaliyah was clear that there was a shift in the house on where she primarily used the restroom. Both women agreed that it wasn't the sole bathrooms that everyone used. They were closer to another bathroom. You might go to the restroom. Miss Melanie Ames's master bathroom was closest to the dining room. So if they were in there and the defendant needed to use the bathroom, that wasn't a problem. Again, she's not hiding things from the court. She's describing their relationship. It may not seem exactly clear cut, and perhaps in hindsight, she's thinking that maybe they should have moved out. Maybe something different should have happened. But that was the situation that worked for their relationship. We're talking about witnesses. Miss Leslie said that the defendant's interview was the best evidence of intent, almost as if that should be the only evidence of intent. But the standard jury instructions also instruct the trier of fact to consider, does the witness have an interest in how the case is to be decided? Does the evidence agree with the other evidence and testimony in the case? And while the defendant gave a reason in his interview to Detective Gentry, the state's argument is not that it was abandoning the other reasons for his intent. The state was saying that based on his admission in that interview alone, that it was for closure, that he placed the camera for closure, that could fall under amusement and entertainment. But the state didn't stop there and abandon the other methods. That's why the state presented the evidence of the defendant in Melanie's bathroom pulling down his pants multiple times, checking the camera to make sure that it captured the majority of a person's body as you're stepping out of the shower. Like pulling down his pants again after that point, seeing his reflection in the mirror, double checking it on his phone. The testimony from Detective Gentry about him masturbating. The state didn't need to present that video to the court. It's in evidence. It's State's Exhibit 8A if the court would like to view it, but it doesn't specifically go to any of the elements, and Detective Gentry testified about what happened. At the end of the day, if all the defendant really wanted was closure, he could have purchased a listening device, as Ms. Leslie brought up to the witnesses. Court knows that may have been another crime in and of itself, but it wouldn't have been video voyeurism. It wouldn't have been an imaging device, and it would have fit with his reasoning that he wanted closure, that he wanted to catch Melanie cheating. He said he put the device in a room where he could catch her talking on the phone, in her bedroom and her bathroom for some reason. That doesn't make sense. If all he wanted was that conversation to get that confirmation that there was some sort of cheating going on, which by the way, apparently was happening 6 months after their relationship ends, so that doesn't even make sense. But if he wants that closure, he doesn't need to point the video camera towards the bathroom. He doesn't need to point the video camera towards the shower curtain. He doesn't need to point the video camera facing out from the dresser where clothes are kept. He doesn't need to point the video camera from the air vent on Melanie's floor facing back towards her bed, where again, you can see her dresser, you can see her side of the bed where she slept. He doesn't need to place it on her nightstand facing outward so that he could see her bed facing the television. He would just need to place it in the room so that he could listen but not hear what was going on. Again, the state isn't abandoning its arguments for intent for either count one or count two as far as sexual arousal gratification. I don't believe that there really is any evidence of profit here. But even for degrading or abusing Melanie Ames, at this point, the defendant didn't stop these actions on his own. The defendant stopped these actions because Melanie Ames caught them. She found him recording, she found the device, and she put a stop to it. He hadn't gotten the closure that he wanted at that point. He hadn't gotten the closure he said he needed. Once he had gotten the supposed closure, what would he have done with that evidence? Would he have presented it to Melanie for degrading her? Would he have peppered her with it? Would he have put it out in the world? We don't know because he was stopped. But that doesn't mean that that was not his intent. We have to look at his actions as a whole. Again, we have to consider his bias when he's telling Detective Gentry what was going on and why he was doing it in that interview. Ms. Leslie also said that if the defendant that morning, Friday, July 17th, if he was going into the bathroom to look for the camera, that I'm not sure I wrote it down exactly, so if I misparaphrase it, I apologize, Your Honor, can you use your recollection of that? But if he, I think essentially my recollection is the argument that he was not going in there looking for the camera. Perhaps he was going in there to chat with Melanie. That doesn't make any sense. She went in there to take a shower. Your Honor could see in that video the state of undress she was in, that her hair was in the towel, she's putting on deodorant, getting ready for the day. What had she told you that she did right before that? She said she sat out on the back porch, drinking coffee with the defendant and talking, like they did every single morning. And when she was done with that, she went into the bathroom. So what at that point is so important that the defendant has to talk to her in that moment that they didn't talk about on the porch, and they can't wait till she's done getting ready. Miss Ames didn't tell you that the defendant ran in there and said, the house is on fire, somebody's dying, there's an emergency. He came in there and he reached for the camera because that's why he came into the room. He knew that Melanie found it because he was watching her, and he wanted to get that camera. And he did know that the camera recorded. Your Honor has your own recollection of the interview, but I counted 3 separate times during the interview where he said he knew the camera recorded. Right after he told Detective Gentry, I believe she clarifies, cuts him off, and asks if it was sound and video. He says yes, it was sound and video. He told her that the camera records and that it has a card on it. Later in the interview, Detective Gentry is asking about the fact that the defendant knew about Aaliyah and Melanie sharing bathrooms, and if he had thought about that. And right after that, in my notes, is where I have him saying that it recorded to the card a second time. A third time in the interview, he says that he didn't store the videos anywhere, just on the card. So 3 different occasions during that interview, the defendant admits to knowing that that camera has some way to store videos on it. Ms. Leslie also talked about the fact, with reference to the defendant's intent about Aaliyah, and she kind of analogized the fact that the defendant put a GPS device in Melanie's car, and he didn't put one in Aaliyah's car. We don't know exactly when that device got put in Miss Ames's car. We know that it was a brand new car, that she'd only had it for a few weeks, and so it had to have been put in the vehicle during that time. We know that the boxes were found in his closet, and I already went through the reasons why we know he was the one who did it, including his own admission. But Miss Leslie brought up the fact he had a second one, and Aaliyah had a car. He may not have had the opportunity to put it in there yet, but there is a second exact same device that he put in Miss Melanie's car, and Aaliyah had a car herself. As far as the two-way communication device, the defendant could not have committed this crime in the manner that he did, the video voyeurism, without that cell phone. He could not have viewed what was going on in the camera in real time and seen what that camera was showing. But for the cell phone, the defendant would have had to take that SD card out of the camera, see what the video was showing, remember exactly where he had placed it in the bathroom, behind the vase, on the nightstand, on the floorboard, etc., and then place it back in that exact same spot to capture the video he wanted. So, but for this two-way communication device, this felony would not have been committed in that same way. Ms. Leslie talked a lot about the fact that there are tons and tons of videos on the SD card download, and that there's only one of Aaliyah. There's not that many videos of Melanie Ames either. Detective Gentry testified that there are approximately 6,900 videos on that device that was placed in various spots in Melanie's bedroom and the shared bathroom. But we only have 13 separate clips that Detective Gentry testified to, and even in the ones that the state showed the court in State's Exhibit 4, I believe it's 5 videos were from 2 separate occasions. So no, there's not a lot where these women were in a state of undress for either of them, but that doesn't matter at the end of the day. What matters is that there is at least one incident where the defendant captured each of these women, and that is when the crime was committed. There's also no element that requires these victims to feel uncomfortable. I think the fact that these victims felt comfortable around him, had no issues being around him, in a bathing suit, out on the boat, whatever it is, frankly, it just makes everything worse. But there is no element that requires he makes them feel uncomfortable before he secretly records them. Finally, Your Honor, I'll leave you with this. Admit what you can't deny, and deny what you can't admit. Jason Lane admitted to Detective Gentry what he could, that he was trying to do this for closure, that this was all about this relationship with Melanie that somehow still existed 6 months later, 5 months later, and that that's all this was, that he was trying to catch her cheating after their relationship ended. That's what he can admit, because that is the most innocent sounding reason for what he did. But the state would submit to you that based on all of his other actions, when he is moving that camera around, the order that these things are happening in, his actions specifically on the 16th that the court saw, pulling his pants down, coming out of the shower pulling his pants down, pulling his pants down in front of the sink. All of these actions together show that the defendant had more than some innocent reason for doing what he did. And at the end of the day, the state would again submit that that reason, that closure, would still fall under this statute, would still be for his own amusement or entertainment, and that he is still guilty of video voyeurism, even if you take that at its face. But there is so much more to this case than that. And the state would ask that you find the defendant guilty as charged on all 4 counts. Thank you.
Thank you.
All right, we've got exhibits 1 through 9. I do plan to listen again to the statement made to Detective Gentry. So that'll be number 9. Any reason why I need to do it out here like we would do with a jury? I didn't think there was particularly, so.
No.
All right, so with that in mind, it's already 11:15. I'll let everybody know, we'll take a lunch break, we'll come back. I do have a separate, in a separate case, I have a sentencing hearing at 1:30. So let's plan on coming back here at 1 o'clock like we did yesterday.
Yes, sir.
All right.
Thank you.
Thank you. And I'll leave the feed running, but it'll be muted in audio and video mute.
Yes, sir. I know, that's just my concern. Do we know if lunch was brought for him?
Yes.
Okay, well, it's good. Okay, just wondering.
All right, very good.
Just be a shorter day, so.
All right, we'll be in recess then.
Okay.
All right, after deliberating, and I'll get the evidence from the back, I'll bring it back out here. I apologize, I left it back there. I find as follows on count one, and this is State versus Jason Lane, case number 2019 CF 902. Verdict on count one, guilty of video voyeurism as charged in the information. Count two, not guilty. Count three, guilty of installation of tracking device or application as charged in the installation in the information. Count four, guilty of unlawful use of a two-way communication device as charged in the information. Are you ready to proceed to sentencing tonight?
So Judge, I believe I would be hiring an expert, to offer some testimony essentially to the court. And then I know his mother would like to be present, to make statements, for court's consideration. So at this time, I would ask for, pass to sentencing next month.
Okay. Let me look on the calendar and see what's available. I calculate that on these charges, it would be a total of 10 years and 60 days, plus applicable fines and costs. 2 third-degree felonies, 1 second-degree misdemeanor. All right, let me look at the calendar. State, do you have any witnesses you intend to call on sentencing?
Your Honor, I will verify with them. I know previously, at least as far as the VOP goes, and I'll talk to Ms. Leslie about that, see if we can work all in together, and we'll have that conversation separately. I know Ms. Carroll wanted to testify previously, both Ms. Ames's did not want to, but I will ask them in the meantime. I guess I would just ask for maybe an extra 15 minutes, of the court's time in case they do want to make statements. I don't anticipate it would be long.
All right. And you anticipate about an hour then, perhaps?
Yes, sir.
Ms. Sosa? All right.
And just, again, I'm not trying to hide the ball, essentially, I'll speak with the client about it, and I know there, in another case, there was a psychosexual that was done, so I don't know if at that time I would have an updated version of that in light of the additional case, and then offer that as information.
Okay. I think we could set it for Friday, March 12th at 10:30. I have one gentleman that'll be here for a negotiated plea at that time, but we've got otherwise plenty of time then in that time block.
Yes, sir.
That's fine.
There's no PSI, he has a prior felony, unless you're asking for a PSI.
Actually, technically on that offense, he did receive a withhold, so he would be
That's fair.
entitled because it's consideration for an adjudication. Do I have a brief moment?
Yeah, you want to talk to your client about it, because obviously, and this is not a reason to reschedule it, but it'll take probably more than 30 days to get a PSI, so.
Because he's never been adjudicated that to be done, or do you want it? Okay. So if she does wish to request a PSI, do we need to, with that in mind, reschedule the sentencing?
Yeah, I'm looking, looking right now. Let's tentatively set it for 8:30 on the morning of Friday, the 26th of March. That is technically during my next trial term. I'm unable to predict right now whether a trial will occur or if it will in fact interfere with that day and time, but that's late in the week, so
Judge, maybe a compromise, to squeeze it in, would you, if the state can do it, would that mean it's 8 o'clock, so that if you do have a trial, potentially at 9, we can have sentencing within that hour?
and we can schedule for 8, but it'll be as soon as everybody can actually get here and get organized and get opened up. We can set it for,
I know that's early for everybody, I'm just,
it's actually before the courts take place here.
oh, okay, all right.
I was about to say, I don't think the clerk's office is until 8:30.
Got it.
Yeah,
Okay,
let's go with 8:30.
fair enough.
Do you need, either party to file any sort of notice for that, Your Honor? It's been a little while.
No, I don't think for this one we'll need a notice.
Okay.
We'll need the PSI order though.
Judge, and I'll talk to my client about it, typically anytime there is a guilty, the defense typically files a motion for new trial, to preserve any issues. Should we schedule, I guess it's a sentence first, so.
I'll take a look at your written motions when you file it, and if I think it needs separate hearing, I'll let y'all know.
Okay, thank you.
Otherwise, I typically take those up at
Same
the
time.
beginning of sentencing, and obviously if it's granted, then we don't have the sentencing hearing. So, all right, is there anything else to take up today?
No, sir.
All right, so Mr. Lang is remanded in, he's already in custody, so he stays in custody.
Sir.
Sure. All right, thank you very much.
Thank you.